Justice Nhlanhla, the ACJ is not with us.
Oh, I'm so sorry.
I have readmitted him, Justice Nhlanhla.
Oh, thank you very much. Thank you.
I'm terribly sorry. Technology let us down this side, but that's because I touched something I shouldn't have touched. Has counsel, has the matter been called by any chance or not yet? Oh,
not yet.
Okay, right. Okay, please, you may call the matter.
Good morning. I am the registrar clerk for this matter. Acting Chief Justice and Justices of the Constitutional Court, all counsel are online. I call the matter of Justice Nhlanhla Lebea and Sango Minye and another for hearing. Counsel are now invited to place themselves on record. Please note that this hearing is being recorded.
Acting Chief Justice, I, on behalf of the applicant, together with Ms. Drake and Nhlanhla Mokhorani.
Thank you, Mr. Georgiadis.
Acting Chief Justice, Justices of the Court, I confirm that I appear for the first respondent, Mr. Menye, on my own.
Thank you very much. As I indicated to colleagues, Mr. Georgiadis will have 10 minutes, the first 10 minutes of his address without interruption, but Mr. Law has waived his right to the 10 minutes of no interruption when he starts addressing us later. Mr. Georgiadis.
Thank you, Acting Chief Justice. Acting Chief Justice, Justices of the Court, we submit that there's a question before this court, and that is whether a non-party in litigation against whom findings are made which are necessary to make the order has a right to intervene in litigation where his dignity and his integrity have been impugned. We make that submission in paragraph 3 of our heads. But before I go on that, we say that the answer must be yes, such a person has a right to intervene. The applicant submits that power can be found in the established common law, and that's what we will submit. But if the court disagrees, the applicant submits in the alternative that the common law on intervention is in breach of his right to dignity and Mr. Lebea's right of access to courts, and that be developed in line with section 39(2) of the Constitution. The relevant facts and background are quite simple. The main dispute arose out of a disciplinary hearing in 2013 and 2014, where Mr. Menye was charged by his employer, the Free State Department of Public Works and Infrastructure, which I'll refer to as the department, appointed Mr. Lebea to prosecute the disciplinary charges against Mr. Menye. In this regard, he was assisted by Mr. Moletse of the department. There were several postponements of the matter, and they were because of the unavailability of the department's witnesses. Only one postponement was occasioned by Mr. Menye. Nevertheless, a factual dispute arose as to whether, as to the costs of various dates of postponement, being the 2nd, 3rd of October 2013 and the 1st of December 2013. There were two conflicting versions, and the first was that Mr. Menye's position was that the department had verbally agreed to pay his fees, and the version of the department was that they were not authorized. Mr. Lebea and Mr. Moletse were not authorized to agree and didn't have authority to bind the department. And although a bill of costs was sent to the department, to Mr. Moletse, and then subsequently sent on to Mr. Lebea, that was for purposes of requiring the authority or the approval of the HOD of the department. Nevertheless, this culminated in what was the magistrates court action, where Mr. Menye sued for those legal fees. In the pleadings, it was said that it was pleaded that Mr. Moletse represented the department, and that there was an agreement and an undertaking on the part of the department to pay the legal costs of Mr. Menye. It's also important to note that it was never pleaded that Mr. Lebea made any misrepresentation. And in fact, there was no allegation of a misrepresentation. All that was pleaded is that Mr. Moletse, in representing the department, had undertaken and agreed to pay the legal fees. The magistrate Majokweni found in favor of Mr. Menye and said that the department was liable for Mr. Menye's costs. But what's crucial to this case, and the fact that distinguishes it from the others, is that without it being put to Mr. Lebea or giving him any notice of Audi in respect of these findings, the court made a factual finding against Mr. Lebea and held that he made a representation on the part of the department which bound the department. And we quote at paragraph 10 of our heads, the court found that Mr. Menye has proven on a balance of probabilities that postponement was agreed on misrepresentation by Mr. Lebea. These are the magistrate's words, that wasted costs would be paid as he obtained authority to do such. So the finding, it cannot be gainsaid that the finding falls squarely and implicates Mr. Lebea's fitness and propriety as an officer of the court. It was even said that his conduct is very strange, quote, very strange and disappointing being an officer of the court. We say that this exposes Mr. Lebea to a potential application or potential charges of misconduct with the Legal Service Council. Justices, we say that the matter, we say that the court ought to give us leave to appeal because it implicates the applicant's right to dignity and his right to access to courts. And it's for this reason that it invokes a constitutional jurisdiction. Mr. Lebea has been refused access to court to seek to vindicate his rights. And if this court finds against him, he would be without a remedy. It's in the interest of justice that he be given leave to appeal, we say. The matter also raises an arguable point of law, and that is whether the common law is sufficient to cater for Mr. Lebea's right to intervene. And if it's not, then that the Constitution will be invoked and Section 10 and Section 34 of the Constitution be invoked to allow him to develop the common law in terms of Section 39(2). Now, we say that Mr. Lebea has a direct and substantial interest in the proposed appeal. He has a direct and substantial interest, and his legal interest is that the case is prejudicial. The order is prejudicial to the applicant to the extent that it necessarily finds that it was the applicant, not Mr. Moletse or someone else, who bound the department. So the sole basis of the magistrate finding in favor of Mr. Menye is her finding that the applicant made a misrepresentation on behalf of the department, his client. We say that the case, we say that he plainly has a legal interest because the issue is whether the applicant entered into the agreement, although Mr. Menye's primarily pleaded case was that Mr. Moletse, not the applicant, entered into the agreement. The magistrate found that it was Mr. Lebea who made the misrepresentation. We submit that the public protector case is of application, and I'll address your justices further on the issues that were raised in the public protector's case. But we say that the High Court judgment in Wynne is authority for the proposition that in certain limited circumstances, a person ought to be granted leave to intervene to address adverse findings against him. And we quote in paragraph 23 from that case of our heads, where we say the court held quote, where there's an attack on the character of a person who is not a party to the litigation, and we underline it is conceivable that there may be a limited right to intervene, provided that it would be essential for purposes of the judgment that the correctness of such attack be considered and decided as part of the court's reasoning for determining the issue between the parties. So the point of departure is that the reasoning was essential for the order, and we're aware and alive of all the cases that say you can only appeal the order and not the reasons for the judgment. But we say that the finding made against Mr. Lebea, not pleaded and not put to him in cross-examination, is so intricately linked to the order that was made that he should be given a right to intervene, especially since it impugns his character. So the High Court in Wynne, and then subsequently supported in Lehapa's case, which we also quote, is authority for the proposition that when it is essential, such a adverse finding should be, such a person in the shoes of Mr. Lebea be allowed to appeal, to intervene. So the magistrate's finding is central to the order and to this application for intervention. The order granted is based upon the incorrect finding that the applicant made a misrepresentation. So we must accept for purposes of the intervention that the finding was incorrect, that if it's held that it was incorrect, that he would be given, that he would have an interest in intervening in the matter and appeal the matter. Justices, we were asked in the directives from the court in April this year whether the case of SA Riding doesn't stand in our way. SA Riding, the SA Riding case was a case of the Constitutional Court, of this court, that was concerned with a varied order which had the effect of transferring a property to a person, and while the property belonged to the state, it was given to a person who had lost land under the apartheid regime, and the occupier of the property had incurred certain costs in developing the property, and the court allowed the association SA Riding to intervene in the proceeding, not because it had an interest in the actual order, but because it had a compensatory interest. So it was decided on this narrow basis, and that SA Riding was given leave to intervene. But we say that the facts in SA Riding are distinguishable for our case because the...
Mr. Georgiadis, your 10 minutes is up, so
Yes.
but you can continue, but you can expect questions from now on.
Thank you, Acting Chief Justice. We say that SA Riding didn't deal...
Mr. Georgiadis?
Yes, Justice.
Is the right of appeal exercisable outside of the provisions of the Magistrates Courts Act in the case of an appeal emanating from the Magistrates Courts, or outside of the Superior Courts Act in the case of a judgment emanating from a superior court?
Sorry, Justice Nhlanhla, I don't understand the question. Is Justice asking me whether there's a right of appeal in the Magistrates Court rules?
No, I'm saying, is the right of appeal exercisable outside of the provisions of the Magistrates Courts Act or outside of the Superior Courts Act? Can you exercise that outside of the ambit of those acts?
No, as I understand it, the right of appeal emanates from the Magistrates Court Act and not the Superior Courts Act.
Oh, so, and you are saying that because here the proceedings started in the Magistrates Court?
That's indeed.
So your point then is you cannot exercise the right outside of the provisions of the Magistrates Courts Act?
No, you can only exercise the right once you have a right to intervene, and then you can appeal in terms of the Magistrates Court Act. That's how I understand the position.
Okay. Now, can you have a look at Section 83 of the Magistrates Courts Act?
Do you have it? I don't have the section before me.
Let me see if I can quickly find it. I will read it.
Thank you, Justice.
So I was far away from section 83. Yeah, I'm there now. This is in chapter 11 of the Act. Then it starts with section 82, but I'll go to 83. Subject to the provisions of section 82, that's not relevant for present purposes. A party to any civil suit or proceeding in a court may appeal to the provincial or local division of the Supreme Court having jurisdiction to hear the appeal against A, any judgment of the nature described in section 48. Section 48 sets out the various types of judgments that a magistrate's court can make. And then B, any rule or order made in such suit or proceeding and having the effect of a final judgment, including any order under chapter 9 and any order as to costs. C, any decision overruling an exception, and so on and so on. Would have preferred for you to actually have it in front of you so that
I apologize, Justice Nhlanhla.
No problem.
My junior has just brought it to up on her laptop, and I've got it before me, Justice.
You've got it now. Yes.
Yes, I do.
Oh yes. So it seems to me that what can be appealed, if we look at A is a judgment, and then B or a rule or order. We all know what a judgment is. We all know what an order is. I'm not sure what they mean by rule there. I did not go to the definition section to see what they mean by rule, but you might also want to quickly have a look at that. But
yes,
let's see if I can't quickly find whether they say anything about Republic, territory. Then the rules, they talk about the rules, which is something else altogether.
Yes, yes.
Yes, yes. So rule is not defined. Maybe rule there means something like a ruling. I have no idea. Anyway,
yes.
So judgment, rule, and order.
Yes.
Do you think an appeal against a factual finding by a magistrate's court would fall under judgment, rule, or order?
You have to appeal the order because the finding is, that's my submission. The submission is that if Mr. Lebea is granted leave to intervene, he will appeal the order that was made because it's very much hinged on the finding that was made against him. I understand that the rules don't cater for this. The magistrate rules don't cater for such an appeal.
But the substance of what you've been submitting to us is, it is more the factual findings that he wants to upset, not
yes.
so the order. The upsetting of the order, if at all, might be something consequential, but what he's fighting about is the factual findings, and that is what he's seeking to appeal against in essence.
Yes, we say, Justice Nhlanhla, that the two go hand in hand, that if the finding is going to be appealed, the order itself has to be appealed. So he falls within the purview of Section 83. He's going to appeal the order. The reasoning of the order is very much a finding that was made to the reasoning or the finding that was made against him on a common law position, alternatively constitutional position.
Will that not purely be a tactical basis so as to get around the hurdle of judgment, order, and rule that is saying, no, I'm actually appealing against the order, because that's not what he's interested in. Will that be a mere so as to get to the factual findings, which is what he has a problem with? saying that I'm appealing,
Yes, that's
which does not really affect him. Is that not a mere stratagem so as to be able to get to the factual findings, which is what he has problems with?
well, Justice Nhlanhla, our submission is that the actual order was made was as a result of the finding that he made a misrepresentation. So he will
But
have
my
to.
point- Yeah, but my point is for him, that's neither here nor there. The order itself is neither here nor there for him as such.
The consequence of the order and the payment of the costs is neither here nor there for him, but the underpinned by a finding that impugns his integrity, and that gives him standing. If you look at the case of public protector, which I was going to get to. If I
Thank
can
you. Thank you. Thank you, Mr. Georgiades.
Thank you, Justice.
Through you, ACJ, can I?
Low, I'm sorry, Mr. Low, isn't that the position you take, namely that you will have to appeal the order, but actually what your client is interested in is the credibility finding against him? Doesn't that isn't that a concession that, as far as the order is concerned, he really doesn't have an interest in the order?
Acting Chief
I
Justice.
accept that as a concession that it is he has no interest in the order. He has an interest in this finding or reasoning. Can I accept that?
Sorry, Acting Chief Justice, you are correct.
Yes.
Our case is in fact precisely that he
Yeah.
doesn't have interest in the order.
Yes, that's Mr. Lowe responding. We're still being addressed by Mr. Georgiades, but I don't know if he's frozen.
No, I'm not frozen. I was on mute, Justice, Acting Chief.
Or did I say Mr. Lowe by any chance?
You said Mr. Lowe.
Oh, I'm sorry. I'm terribly
Yes,
sorry.
you said Mr.
I apologize. I've caused confusion. No, I'm sorry. Mr. Georgiades, I meant to address that to you. Yes.
Thank you, Acting Chief Justice. Our answer is to be found in the High Court Authority of Wynne, the case of Wynne. And what I quoted earlier was that the court said in that case it's conceivable that there may be a limited right to intervene, provided that it would be essential for purposes of the judgment. So we say that it's not a credibility finding. It's actually a finding against a finding that leads to the order, a finding that is so necessary and so closely linked to the order that it can be said he has an interest in the order as well.
So you say he has an interest in the order because the finding is a finding that is essential for the making of the order.
Correct, Acting Chief Justice. That's our submission.
I take it that you seek to distinguish it from a case where the finding is not essential for the order to be made.
Correct, Justice. Correct, Acting Chief Justice. That's exactly what we submit.
And what is the effect of the fact that, as I understand the position, the MEC has complied with the order, and as far as the Mr. Menye and the MEC, the matter has ended?
That doesn't divest, Acting Chief Justice. It doesn't divest Mr. Lebea from the interest that he has in the matter. If one looks at the case of public protector that I was coming to, the flexible approach that one takes to standing in bringing review applications in that case applies equally to Mr. Lebea. The fact that the amount has been paid, we say does not impact upon his interest or that he has a direct and substantial interest. The department may have paid, but his interest and his direct and substantial interests remain. And the fact that it was never put to him in cross-examination, nor was it pleaded that he had misrepresented, gives him a direct interest.
But at a practical level, of course, is in the position that if he succeeded, that is the applicant, it would he would effectively restart litigation that has ended between the parties.
Well, it's only ended because you can say that it's ended between the department and Mr. Menye, but it's very much alive as far as Mr. Lebea is concerned.
No, I accept that from his point of view it is, but as between the person who brought the action in the magistrate court, the plaintiff, and the defendant, that the plaintiff alleged owed him money. As between those parties, the matter has ended, it's buried as far as they are concerned. If the applicant is successful, the practical effect would be to unravel or bring all of that back. And of course, I don't know whether what those parties might do. Maybe the MEC, having complied with the order, can't turn around and do anything just because there is now somebody who is appealing. But that's what it seems would happen. Are you submitting that the appeal would only be between the applicant and Mr. Menye, because the MEC would have no right to pursue anything having complied with the order?
Yes, I would submit that such an appeal would be between Mr. Lebea and Mr. Menye. I'm just speculating that the department, already having complied with the order, would not have an interest in pursuing the appeal.
And then, of course, you yourself have said that the finding about which Mr. Lebea is aggrieved was essential for the order that was made.
Yes.
If you are correct, in that submission, and it's you may well be correct, what it would mean is that if ultimately Mr. Lebea is granted leave to intervene and he pursues an appeal and succeeds, that what would happen to that order is the position, not that the appeal court, if it overturned that finding of the magistrate's court, that it would have to set aside the order in terms of which the MEC already made payment.
It would have that effect, Justice, Acting Chief Justice.
And if that were, if it did that, would the MEC not be entitled to say, well, I want that money back because I only paid because there was an order saying I must pay, and I thought the order was correct. Now that it has been set aside, the money must be returned, or would it not be open to them to say that?
It would be open for them to say that, Acting Chief Justice. They would be entitled to claim the money back.
So if that is correct, if you are correct in saying that, would you accept that although if the remedy that you seek, if it can't be granted, it would have to be granted if it's an appropriate case, but one, the court would have to be quite careful in matters which could end up with that, with those consequences?
Yes, the court would be quite careful, but in this matter, the finding is so essential and so intricately linked to the order that without the finding, there cannot be an order. And the order
Yes,
be reversed.
yes,
Succeed, I'm assuming. And for purposes of this argument, we must assume that those facts can be proven and assume that the appeal can succeed.
yes. Okay, all right. I think there was a colleague who wanted to ask a question earlier.
Yes, ACJ. It relates to what you've been debating with Mr. Georgiadis, but let me ask a question. Let me ask a further question, ACJ.
Yeah.
Mr. Georgiadis, in the usual course, when one launches an appeal, would then have to make allegations that the court, not that I like the term, erred. They would have to say in these respects. I'm interested to know that if Mr. Lebea were to succeed here, what would he really be challenging? Would he say the court erred in those findings that he made? And then what would he be seeking? My question is on the cause of action. Because remember, the list between Mr. Menye and the MEC related to the wasted costs. Now, if Mr. Lebea were to appeal, he would be appealing against findings made against him, not against the wasted costs. So I'm interested now to look forward, if we were to be inclined to be with you.
Yes.
What would be decided on that appeal?
Yes, I think that's a two-stage question, and let me attempt to answer it, Justice Chiki. The position is that he would challenge that the learned magistrate erred in finding that he had misrepresented in circumstances. Let's assume for purposes of the argument that, excuse me, that it had been pleaded correctly that Mr. Lebea had misrepresented that he had authority. Then the learned magistrate may have, or Mr. Lebea may have applied at that stage for leave to intervene, or the magistrate would have said that there's a non-joinder, and he would have required that Mr. Lebea be joined as a party in order that he could have something to say about this alleged misrepresentation. But in fact, what is pleaded is that there is no misrepresentation at all. In fact, the misrepresentation isn't even put to him in cross-examination. In that respect, the learned magistrate erred in simply going on a frolic of her own and choosing that there was a misrepresentation made by Mr. Lebea. So if he were to appeal, that would be the grounds of his appeal. The second part of the question that I think Justice is asking me is what would he be asking for? He'd be asking for the order to be overturned because it is so intimately linked to the finding against him. If he were to ask for the finding, the order would follow. Or if you asked for the order, the finding would follow. The two are intricately linked in our submission.
Would his cause of action be the same as the one in the list between Mr. Menye and the MEC?
His cause of action would be the same, yes, because the dispute, the sole dispute that is the magistrate found upon is whether there is an agreement to pay the costs. So if there's no agreement on the costs, then there's no agreement that there cannot be a finding that Mr. Lebea agreed to pay the costs.
But the cause of action in the list between Mr. Menye and the MEC was the wasted costs.
Yes.
What would be his cause of action?
His cause of action is simply that there was no agreement to pay the wasted costs. And the finding that is made against him, the magistrate found on that basis. She found on something that was not pleaded, and also found that there was an agreement to pay the costs. So his cause of action would be that there was no agreement.
I'm not going to belabor the point. Let's go to jurisdiction, Mr. Georgiadis.
Yes.
You are relying on public protector. Am I correct in saying that public protector is a judgment of the SCA? And
Yes.
it predated South African riding?
It did predate South African riding, but we we say that the criteria of the interest that is referred to in public protector, the direct interest, it falls squarely within our facts. The fact that it was not an application to intervene, but an application for review in our submission doesn't make a difference. The SA riding case didn't grapple with the essential finding being so intricately linked to the final order.
So are you seeking that this court should distinguish your case from South African riding case?
Yes, absolutely, Justice Chiki. And the basis for that is that here there's a finding that underpins the order. In SA riding, that wasn't the case. Although this court did allow an intervention on the basis that SA Riding Association was going to claim a compensation.
Thanks, ACJ.
Thank you, Mr. Georgiadis. I'm sorry, Mr. Georgiadis, I've heard you 2 times saying that the applicant had made a misrepresentation, was not put to him in cross-examination. But I thought I read an affidavit by Mr. Lebea in which he said that had not been pleaded, but it was put to him in cross-examination. Have you got your facts right?
No, my submission is indeed correct. What I've said twice is that he does say in the affidavit, that it was not put to him in cross-examination. I can find the reference, Justice, and perhaps refer you to it in my reply.
Yes, no, that's fine. Justice Nhlanhla.
Thank you, ACJ. Mr. Georgiadis, I just want to test further your repeated reliance on the close link between the order and the factual findings. Let us assume that there was an appeal by Mr. May. Let's say, how should I? But I want a situation where there was an appeal between the parties themselves. And let us leave out the question of the underlying basis for the appeal for a moment. And then intervention is sought in that context. So there is actually an appeal, a live appeal. And the Court of Appeal says, I am least concerned, I am not in the least concerned about the factual findings that were made against the intervener. It is perfectly possible on the facts to uphold the order without any reliance on the adverse factual findings that were made against the intervener or person seeking to intervene, or whatever we may call that person. And then the order stands and it is upheld. But now, the upholding has nothing at all to do with the contentious facts that the intervener is seeking to set aside. So those facts stand. And the problem that the applicant is presenting us with, which is that I am an attorney and there are these findings against me and absolute integrity is expected of me. And yes, this goes against that. What then would the intervener do in that scenario?
The intervener
is now I've taken away your close link argument.
Yes. Then I would have a difficulty. My intervener would have a difficulty, Justice Nhlanhla. He wouldn't be able to. He would have to argue that he could still make an argument about his reputation, but he would have a difficulty in intervening, firstly, and secondly, he would have a difficulty in overturning the court order because there are other factors. In the example that you posit, there are other factors that would play against him. So he would just be a credibility finding against one of 10 witnesses, let's say, in that example, he wouldn't be able to overturn the order, and that essential link that I've drawn would be broken.
Thank you.
In that situation, Mr. Georgiadis, exactly the situation that Justice Nhlanhla raises, which you indicate would present a difficulty.
Yes.
In law, what does a person in Mr. Lebea's position do? Now, I'm saying in Mr. Lebea's position, but having taken out that link that, as Mr. Justice Nhlanhla indicated, I mean, this situation could happen to anybody. It could happen to a judge who finds himself having to testify, whether it's a criminal matter, it's a civil matter in the magistrate court or in the high court, in a dispute involving other people, or a criminal matter because he was a witness to a crime or to certain events. The magistrate makes a finding that he or she was dishonest or lied, and for purposes of this argument, let us assume that the magistrate or judge concerned was completely wrong, absolutely wrong. There was no evidence to justify that finding. That judge would, it would be difficult for that judge to go back and sit on the bench and hear cases when a court has found that he or she was dishonest in his or her evidence. And what does he do? What does she do? She was not a party to the matter. He or she was just a witness.
Can I answer that, Acting Chief Justice? I think that in that circumstance, if that magistrate was absolutely wrong, if he committed an irregularity, that judge would be able to take it on review in terms of Section 22 of the Superior Courts Act. But generally, if I can take it back and take out the absolutely wrong on the part of the magistrate and say that the magistrate does make a credibility finding, that will be left without a remedy. She wouldn't be able to do anything. The situation where in the Zuma case, the case that my learned friend has argued in his heads, the NDPP versus Zuma, the judgment of his lordship, then Lordship Justice Harams in the Supreme Court of Appeal, where after the Nicholson judgment, there were officials like the former president, Mr. Thabo Mbeki, that wanted to intervene and so-called set the record straight. They were not given that right to intervene because they were not held to have a direct and substantial interest. So they were left without a remedy. But in that case, there was no argument to develop the common law. And we've distinguished that in our heads to say that there was no argument to develop the common law in line with the Constitution. But generally, such parties are left without a remedy in the example posited by Justice Nhlanhla. But I'm glad Justice Nhlanhla asked that question because I'm able to then distinguish and say that our case, because of the essentiality and the closeness and the necessary finding underpinning the order, that distinguishes our case from the example posited by Justice Nhlanhla.
So on your submission, such a witness, if there are grounds to have the finding reviewed, that would be one route, but it may well be a situation where the magistrate or judge, well, if it's a judge, is in the position that there would be no review. if it's a high court matter, there would be no review. So that places us back to where we are, I think. But even within the context of a lower court, you could have a situation where such an adverse finding is made, but there are no grounds to review, but it's wrong. It's the kind of finding that could only be overturned on appeal, not on review. So the question is the position that somebody who finds himself or herself in that situation would just have to stay with that adverse credibility finding, which if they were able to appeal, it could be overturned on appeal. But if they are not able to appeal, they will just have to stay with it. And what happens, for example, if it's a judge, or it could be an advocate or attorney or somebody else, that could lead to the end of their career, maybe, I don't know.
Well, one would assume if there's a complaint to the Judicial Services Commission, that judge would have a right to argue, to state her case. But I'm getting away with the example. What I want to come back to is what Justice said, that person, that judge will be left without a remedy. That is the position in the common law. There's nothing preventing that judge from arguing that the common law ought to be developed because her right to dignity and her right of access to court has been infringed, which is what we ask for in the alternative in any event.
Yeah, no, that's fine. I think we can deal with that in due course. Let me see if there may be more colleagues who had questions.
Acting Chief Justice, if I could just ask one or two questions.
Yes.
Mr. Georgiadis, I'd like to just take up the Public Protector case and SA riding. Public Protector concerned a review by an affected party against the Public Protector's report. Is that correct?
That's correct.
SA riding was concerned with intervention in court proceedings.
That's correct, Justice Rogers.
Now, we can leave to one side the question of standing in review. It could be assumed in your client's case, just as in the Public Protector case, that if there were grounds for review, you could take the magistrate's decision under review. But apart from that, it seems to me there's a distinction between standing in order to take an inquiry report under review, because fairness wasn't observed in the process of collecting evidence, and court proceedings on the other. So as I see it, I don't see a conflict between the two cases. They are dealing with different things. But in that regard, I'd like you to consider a brief passage, because this question of intervention in these circumstances has been considered in other jurisdictions. And in a Canadian case, reference was made to the fact that parties can sometimes intervene to set aside the results of commission's reports. But then, the case I'm reading from happened to be one of a solicitor who had been harmed by findings in proceedings. And the judge said court proceedings are significantly different from royal commissions. Civil trials are not general public inquiries designed to uncover facts, but rather focused investigations designed to resolve private disputes. It is appropriate that the process in a civil trial be controlled by the parties. Their rights to present evidence and arguments as they see fit ought not to be interfered with lightly. This is particularly so in the light of the trend towards longer and costlier litigation. The court should be wary of any developments that have the potential to make litigation more complex and costlier. Would you recognize that distinction to the approach of standing to attack the investigative reports as against intervention in private court proceedings?
I appreciate the distinction, Justice Rogers, but I can say that in our matter, the significant difference is that although the litigation was between the parties and they had the right to control it, once the magistrate went upon this finding that wasn't of dishonesty and misrepresentation, that finding wasn't underpinned by anything in the pleadings or anything that was put to Mr. Lebea in cross-examination. That's the distinguishing feature. It then allows that that litigation that's where the parties are free to control that litigation in court proceedings, it then brings down that protection.
So if the magistrate in this case had confined herself strictly to the pleaded case and
Yes.
said, I presume your client knew when he was called as a witness that there was going to be a credibility finding between the witnesses on the one side and the other as to what was actually agreed. And if at the end of the trial, the magistrate had said, I find Mr. Lebea's evidence dishonest, his denial of reaching an agreement dishonest, and I accept the plaintiff's evidence. That would have been squarely the raised issue. I'm not sure that saying that he misrepresented the position is materially different to that, but it would be an equally damaging finding. Would that change your argument about his interest in the proceedings?
It wouldn't change my argument if he was the sole person whose dishonesty led to the finding, and that essentiality or that close link is unbroken. If, for example, and I just want to expand on that, if for example, the learned magistrate had assessed Mr. Moletze as well and found him to be dishonest and found that he had misrepresented as well, then our task would be all the more difficult. But in this case, the court order and the final order that the magistrate issued was really underpinned by one misrepresentation only, and that's my client's. Or even if I don't refer to it as a misrepresentation, but an untruth, is my client's. That gives him a direct and substantial interest.
But then why didn't if your client has a right to intervene at this stage, why did he not have a right and have sufficient information to know that he could have intervened before the trial? Because he must have known that there was only one of two findings available to the magistrate. Either his evidence would be rejected as untrue, or it would be accepted.
But in the pleadings, there was no case made out against him. All that was said is that Mr. Moletze represented the department, assisted by Mr. Lebea, in concluding an agreement to pay the legal costs. So
yes, but when your client goes ahead as a witness, he's called as a witness, he must know that in respect of his evidence, the magistrate can either find him to be truthful or untruthful, because there are direct contradictions between the pleaded case and what Mr. Lebea was about to testify.
Well, at that stage, perhaps the magistrate or my client could have asked that they be given leave to intervene, but without any notice and without it being put to him in cross-examination, there's suddenly a finding that he misrepresented.
It is true that sometimes judges or magistrates make peripheral factual findings which are adverse but which do not affect the result. But generally, the process of fact-finding in litigation is to find the facts that are relevant to the outcome. So yes, most facts found in a case will have the close connection for which you argue. And to accept a right of intervention of the kind your client argues for now would really mean that in every case where it is anticipated that witnesses on one side or the other may be disbelieved on matters material to the outcome, they would all have a right to ask to intervene on the footing that, depending on the outcome, their evidence may be disbelieved.
No, there's a lot of authority that says if they don't have an interest in the order, that they not be given the right to intervene. But this case, Justice Rogers, is not about credibility. It's about fact. It's not a case where a witness is found to be dishonest and it's simply left at that. The example that you posit, or the situation that Justice Rogers that you posit, ignores the Wins case and the Lahapa judgment that followed Wins case. There's got to be that necessary link, or that essential link between the finding and the order.
Yes, but your client has an interest in whether his version is true or not, because if it's rejected as false, his reputation is harmed. That's his concern. He doesn't have an interest in whether the department has to pay the money or not.
Well,
so I don't understand the distinction between his concern and interest in the outcome than any other material witness. When a company calls employees or third-party witnesses, which affect whether the company is going to have to pay money, if the witnesses are disbelieved, they have no interest in the relief sought, but their interest is reputational. And how is your client's interest different? Just because he was an important witness on a material issue.
But Justice Rogers, our facts are so egregious that finding of the magistrate really came out of nowhere. And that's what distinguishes us from the other cases where credibility findings are made. This was a factual finding. This was a finding that he misrepresented when that case was not even pleaded or even put to him in cross-examination. In that respect, the magistrate, with respect, the learned magistrate erred.
Well, isn't a case which comes out of nowhere, as you put it, you emphasize the egregiousness and that it comes out of nowhere. That suggests your client might have a right of review. But we are concerned with questions of whether in the ordinary course, a witness at risk of being disbelieved as a dishonest witness has a right to intervene on the merits as opposed to review.
Well, generally, Justice Rogers, your situation or the facts that you paint are that if there's a credibility finding against witnesses in a case, and I think my learned friend relies on the Tulu case, where parties want to intervene and set the record straight, that generally, as a principle, should not be allowed because they don't have an interest in the outcome of the case. But then I retreat once more into the Wins case and the essential link between the finding and the order.
Yes, thank you, ACJ.
ACJ, may I?
Yes, you may. Thank you.
I'd like to take that further. Thank you, ACJ. Mr. Georgiades, about Win. Can we just look at Win briefly? Win, yes. The Fons at Origo was a fight between the two brothers about disputed wills of their late mother. And the police seized certain documents from the applicant, Mr. Win, and from his attorney. One of those documents concerned an affidavit by the applicant with allegations against a third party, happened to be a retired judge. He then approached court on an urgent basis, Mr. Win, and asked for these documents to be returned. The party settled the matter, him and the police. But on the day that the settlement was supposed to make an order of court, the retired judge filed an application for intervention because he said his reputation was being slandered by the scandalous, irrelevant, and unnecessary damaging allegations against him. Now, in that case, did the court not find against the retired judge, against the third party, and the court reasoned that there was no list between the judge, the retired judge as third party, and any of the other parties, Mr. Win in particular, and the issue was settled, and the court said that your rights must be directly affected by a list, an issue between you as intervening party and the parties to the litigation. Is that case not in effect really dead against your client on what you've, because you seem to rely heavily on Win. It seems to me that that case is against you, Mr. Georgiades.
The facts of the case, the facts or the outcome of the case seems to be against me, but the court did say that there has to be an essential link. In that case, I didn't find this essential link.
Yes.
I rely on the principle of essential link, and that's why I also rely on the public protector case. And I see no distinction between the interest and the standing that one may have and the right to intervene. That Justice Rogers said to me there's a difference. With respect, I should have addressed him on the point, but I don't see the difference. One can have an interest, especially if courts are on the question of standing, and the journalists in the public protector case were bestowed with standing. That can't, with respect, be any different in relation to an interest that one may have in litigation, although there is this talk of a protection by the parties. But to answer your question, the facts of the case the court found and I just want to find the quote, that there was this remoteness between the learned judge or the judge being defamed and the outcome of the matter. And it found that there were allegations made against the third party were directly an issue between the litigating parties and would necessarily have to be decided in the course of judgment on the merits. I've got a quote. I've quoted the case as it was quoted in the Lahapa case in paragraph 25 of my heads of argument, of our heads of argument. And can I quote? Can I read the quote, Justice Majid?
Yeah, of course.
It says, assuming without deciding that the above decisions are correct, it seems obvious that in each case, the reason for granting leave to intervene was that the damaging allegations against the third party would necessarily be an issue between the parties to the litigation. So I just pause there to say that in the Wins case, there was it wasn't a case that would necessarily be an issue between the parties to the litigation. And that's the distinguishing feature between Win and my case. It would have been impossible for the court to give judgment in those cases without deciding whether the third party had or had not committed adultery. And the effect of the judgment would therefore have been to decide the correctness or otherwise of the attack on the third party's reputation. The same position arose in Vadwa versus Budre. The defendant alleged fraud and collusion on the part of a third person who was not a party to the action. And then it says, in principle, the full court accepted the proposition that a man's character being beyond all price, the third party should be entitled to intervene. But this again was a case where the allegations made against the third party were directly an issue between the litigating parties. So that, with respect, is the distinguishing feature. It was the credibility finding, or the finding against my client had to do with the issue between the department and Mr. Menye.
Well, my colleagues have already traversed this. I'm not going to go there because I read it differently. But let me lastly just go to NDPP versus Zuma. It seems to me that case is more on point with the present one. You've sketched the background. Former President Mbeki and other members of government felt aggrieved by the reasons in the judgment of Nicholson J. And they sought to intervene. And this is what Harams JA said in Harams DP said in paragraphs 84 and 85, and I'd like to read it because I think it's important. The intervention application, and at paragraph 84, it ought to be apparent by now that Mr. Mbeki and other members of government had ample reason to be upset by the reasons in the judgment, which cast aspersions on them without regard to their basic rights to be treated fairly. It is not necessary to revisit those issues. And then in paragraph 85, this is the important part. Nevertheless, to be able to intervene in proceedings, a party must have a direct and substantial income in the outcome of interest in the outcome of the litigation. The basic problem with the application is that the applicants have no interest in the order, but only in the reasoning. They are in the position of a witness whose evidence has been rejected or on whose demeanor and unfavorable finding has been expressed. Such a person has no ready remedy, especially not by means of intervention, to be able to intervene in an appeal which is by its very nature directed at the wrong order and not at incorrect reasoning. An applicant must have an interest in the order under appeal, and the applicants do not have such an interest. Is your client, Mr. Lebea, not in the same position as President Mbeki and other members of government?
Well, number one, there are slight nuances, Justice Majid, and that is what I've already belabored, and that is that the pleadings didn't suggest that he had misrepresented, nor was it put to him in cross-examination. But be that as it may.
Sorry to interrupt, but as I read the case, it was the same in NDPP versus Zuma.
Well, there were allegations, or there were facts found by Justice Nicholson that implicated the reputations of Mbeki et al. Of Mr. Mbeki et al. And that's correct. That's where there is a similarity. But in this case, he did recognize the lacuna, and we make that point in paragraph 46 of our heads of argument, where we say in National Director versus Zuma, the Supreme Court of Appeal found that the aggrieved parties had ample reason to be upset. And I think you've quoted that, by the reasons in the judgment which cast aspersions on them without regard to their basic rights to be treated fairly. He then says, quite importantly, however, they make the applicant's desire to intervene at the appeal stage understandable. So he recognizes that there's a lacuna, but his lordship declined to remedy it. And in that case, he wasn't asked to invoke to develop the common law. And that's a distinguishing feature. As an alternative, we ask that the common law be developed in line with section 30.
and I understand that, but it seems to me that Mr. Lebea's desire to intervene is also understandable, but he's got no right in terms of the jurisprudence as it stands.
Well, this court can invoke that we submit that that with respect that this court should invoke its constitutional as an alternative, its constitutional standing and intervene because his right to dignity and his access to court has been implicated. And we say that on an exceptional basis, on exceptional facts, and not as a general rule as on a credibility finding that every person who's aggrieved by credibility findings should have the right to intervene and challenge those in an appeal. We strictly restricted to our facts. But his lordship, with respect, perhaps erred in the Supreme Court of Appeal and should have given the right to intervene because their dignity was implicated and their rights were implicated, and they should have been given an opportunity to set the record straight.
Thank you, Mr. Georgiadis. Thank you, ACJ.
Thank you, Justice.
Thank you.
Justice, if I may, please.
Okay, Justice Theron.
Thank you, ACJ. Mr. Georgiadis, just to follow up on some of the final submissions that you made in response to questions put to you by Justice Majid regarding the development of the common law. If this court was to develop the common law, what interest should be protected?
Well, the right to dignity on the part of the aggrieved party.
Isn't that too broad, Mr. Georgiadis? Wouldn't that open the floodgates to all witnesses where who are disgruntled by adverse credibility findings? Let me make the question more specific. Should we protect those people who may have a professional interest only, or should the common law be developed to protect every single witness against whom an adverse credibility finding has been made?
I would submit that the facts of this case are that you're faced with a professional who's
I'm sorry to interrupt you,
yes.
But we first deal with the law. If we're developing the common law, we would develop a general principle. And that's what I'd like us to deal with. Let's forget about the facts of this case for a moment, because if we develop that law, that principle will then apply to all other cases. So the applicant is suggesting that the common law be developed. I'm trying to tease out in what way, in what respect is the applicant suggested. What would the content of that development be?
Yes, I'm not suggesting, Justice Theron, that we develop a general rule that every single party where credibility findings are made against should have a right to intervene and challenge. And I'm not suggesting that there be a distinction because my client happens to be a professional, where in circumstances of his profession.
So I want to know, what is the suggestion that you're making, Mr.
The suggestion is this, and it's found in paragraph 51 of our heads. We submit that the common law be developed to a limited extent, and the limited extent that a person who has a legal interest in an issue that is essential for purposes of the judgment has the right to intervene in such proceedings. It's aptly put. I can't put it better than that. It's in paragraph 51 of our heads.
What is the legal interest? How would you define that?
He's got a legal interest because of his reputation and because his reputation has been impugned. But his legal interest arises because the finding against him was essential for the purposes of the judgment or the order that was made. And we said that the general proposition would be that it would be to a limited extent that where the finding is based or the reasoning is based on findings that are essentially linked or intricately linked, that are not too remote, to borrow from public protector, that in those circumstances there should be a
Let me see if I understand what you're saying, Mr. Georgiadis. You are saying, where does the legal interest? Now I'm trying to understand what the legal interest would be. Would there be a legal interest to protect the right to dignity?
Yes.
So that would apply to everybody. Everybody against whom an adverse credibility finding has been made could allege that their dignity has been impaired as a consequence of that adverse credibility finding, and their legal interest would be to protect their right to dignity.
No, the legal interest goes further than that. There's a policy reasoning, and the policy reasoning is that where the person can show, or the party can show, the intervening party can show that there is an essential link between the finding and the reasoning and the order, that the court should come to his assistance, that the common law should be developed in that regard. And obviously that's underpinned by the right to dignity and the access to justice, the access to courts.
Yes, I'm still on the legal interest, Mr. Georgiadis.
Yes.
And trying, if you can try to help us to identify what the legal interest would be.
Well, we've put it as a legal interest. The legal interest is the direct and substantial interest that he has, that there was a finding made against him that impugned his reputation.
And that would apply to every single person.
No, it wouldn't.
Just let me finish, please.
Sorry, Justice.
Every person against whom an adverse credibility finding is made can claim that their reputation has been impugned, and they have a right to protect their reputation. So then, if that is the way in which the common law is developed, it would have the consequence that every person against whom, or every disgruntled witness against whom an adverse credibility finding is made, can then apply to appeal, or has an interest in that matter.
Sorry, I apologize for interrupting, Justice Theron. Only to the extent that that person can show that the actual order is necessarily based upon the finding of adversity against him or her.
Yes. Thank you, Mr. Georgiadis. Thank you, Acting Chief Justice Sondo.
Thank you, Justice Theron. We are 10 minutes past normal tea break, but maybe I can see whether there were colleagues who still wanted to put questions to Mr. Georgiadis. And I'm grateful to Justice Theron for canvassing the issue of development of the law, because earlier on I said Mr. Georgiadis could deal with it later. So if there are still some questions from the colleagues, we can look at that. Maybe Mr. Georgiadis, on the issue of development of the common law, is there anything further you wanted to say?
I can only refer to the court to paragraph 50 and 51 of our heads of arguments, that if the common law is that even the common law ought to be developed to the limited extent that persons in the position of Mr. Lebea, whom a necessary finding is made to make the order, have a sufficient interest to intervene. I've already made that point with Justice Theron. I don't know if there's any other point that we can make on that regard. If I can just take a brief moment to confer with my junior. I'll just put myself on mute if I can, with your permission.
No, let's not do it that way, because we will take the tea break.
Perhaps I can,
maybe in reply, or when we come back, I can give you 1 minute if you have something that you left to put. But let me put this question. Is it possible that the difficulties, practical difficulties in trying to develop the common law to accommodate the issue of witnesses who find themselves in this situation are so many, is that when one has to think about what the consequences would be of developing the common law and creating maybe a dispensation which either allows every witness against whom credibility findings are made to intervene and appeal. For example, matters that have been settled and finalized between the parties just because they are aggrieved by the findings against them. And also creating a distinction, saying, well, if you are a professional, then you fall into the category that is given this right to intervene. If you are not a professional, that's, you know, you can stay with this, with a credibility finding and have no remedy. Is the position that the difficulties, the practical difficulties and legal difficulties might be so many that maybe it's not desirable to go that route? And maybe people who find themselves in these situations might have to say, well, I'll issue a public statement in which I put my case and let the public make up their own minds whether the magistrate or the judge who says I was dishonest as a witness is right, or I'm right, if I've got no forum where I can go.
Acting Chief Justice, I don't propose a general rule that all credibility findings made against witnesses be challenged. But as I said at the beginning of the case, and I'm sorry to repeat it, but that this case is not about credibility. This case is about a factual finding that was made that underpins the order and is so intricately linked to that order that it's an exceptional circumstance. So that's why I submitted to Justice Turon that it's a limited extent that a common law would be developed, so that a person who has a legal interest, such as a person whose reputation has been impugned, can show that it was essential for the purposes of the judgment that such an adverse finding be allowed to challenge that. And of course, he wasn't given any right or any notice that there would be such a finding made against him, that he misrepresented. I mean, those words echo dishonesty, and that impugned his character and put him at risk of being struck, possibly even struck from the role of attorneys. But facing misconduct charges.
Okay, thank you, Mr. Georgiadis. We are going to take the tea break now. We are at 28 minutes to 12. We'll take the tea break. When we come back, maybe I will hear Mr. Lowe, and if you have anything, then you can deal with it in reply, Mr. Georgiadis.
As you pleased, Acting Chief Justice.
Yes. Okay, let's take the tea adjournment now, and let's resume at 10 to 12.
As the court
I
please.
think we are 28, 27 minutes to. We adjourn.
Court will adjourn until 10 to 12. Please note that during the adjournment, you're welcome to switch off your video and mute your microphone, and then rejoin with video and sound when the hearing recommences at 10 to 12. Should you exit, please use the same link to rejoin the hearing.
Are we all back? Thank you. Mr. Lowe, you may address us.
As it pleases the court, Acting Chief Justice. I think as a starting point, I just need to deal with the issue of the one specific finding which has been focused on, and that deals with the fact that the magistrate found that there had been a misrepresentation regarding the authority. One must not lose account of the fact that if one reads that judgment, one will note that the magistrate found herself in the situation that she had to make a credibility finding or to decide which side's evidence she would prefer. And that wasn't the only finding which she made. I don't want to venture suggesting the basis for her using those words, but she was obviously dealing with a sort of an ostensible authority. It seems like it when she made that finding, but she does deal with the fact that the applicant and the other representative of the department, Advocate Moletsi, did not support one another on crucial issues, specifically relating to what happened surrounding their venture to the HOD and what happened when they returned. And on that basis, there have been suggestions by the justices, and I think Acting Chief Justice yourself said, well, what would happen if a leave was granted and an appeal was upheld, but not on that particular ground? Where would the applicant be? And my submission is, in any event, that one must bear in mind that was not the only ground upon which the magistrate came to a finding in favor of Mr. Menye. And I don't know whether the intended appeal would be the correct procedure. However, if I can move on and state that it would seem that there's no dispute or issue that the state of the common law is quite clearly expounded in the judgments which have been dealt with, inter alia SA writing, which specifically deals with the issue of the fact that the right must be affected. The right that the party says that he has to intervene is a right that would be affected by the order of court. And if one reads SA writing, it deals specifically also with the issue that there must be a list between the parties. And one can take it further and deal with the Wynne judgment, where...
I'm sorry, Mr. Law. I just remind colleagues that you waived your right to an address without interruption. Yes, you may proceed.
Thank you, Acting Chief Justice. Where in Wynne it is said, I can conceive no respect in which attack on the intervening respondent's character can be said to give him an interest in such right or such subject matter. Even more is this so, whereas here there is no longer any subject matter in the litigation because the litigation has been settled and no decision is called for. In Kasu, that is exactly the scenario. The litigation has been settled and there is no list anymore. And then if I take it further, I think a more pertinent judgment where the scenario was the same, and amongst the applicants was also a practicing attorney. And that is the matter of Zulu. I hope I am pronouncing it correctly.
Tolu, Mr. Law.
Thank you, Acting Chief Justice. I appreciate that. I think in that judgment, it's important just to emphasize certain portions thereof, just to show how on all fours it's the same. There, the court dealt with what direct and substantial interest is. And then in paragraph 57, it says that the court found that they were consequently in the position of witnesses whose evidence has been rejected or on whose demeanor an unfavorable finding has been expressed. and that such a person has no ready remedy, especially not by means of intervention, to be able to intervene in an appeal which is by its nature directed at a wrong order and not at incorrect reasoning, an applicant must have an interest in the order under appeal. Importantly, I've also quoted paragraph 58 from that judgment, where it is stated that, as must no doubt have been evident from the above, the applicant's main purpose for their desire to intervene in the proceedings is that their dignities, good names, professional standings, and employment prospects have been negatively impacted by Rogers J's findings. Now, that's exactly what the applicant in this case says. It says, my good name and reputation and my ability or my competence to practice has been impeached and violated. And he says, I need to rectify that somehow or other. And if the law presently does not allow me a right of appeal or a right to intervene, then the common law must be extended. Unfortunately, I think for the applicant, the position is that he relies substantially on the two constitutional rights in terms of section 10 and 34 of the Constitution. One of them, obviously section 34, being access to courts, which determines that everyone has the right to have any dispute that can be resolved by the application of the law, decided in a fair public hearing before a court, or where appropriate, another independent and impartial tribunal or forum. I just want to go back a bit to the interest and say that I think it's quite clear that the applicant didn't have any interest in the subject matter of the litigation in the Magistrates Court. The finding that was made was part and parcel, quite clearly, of a credibility finding. And it was in fact necessary for the magistrate to make a credibility finding. So the argument that it wasn't necessary for her to deal with that, I think is not correct. What, however, might be possible, and I submit this based on section 34 of the Constitution, the question here has been asked, what would the position be of a professional person and maybe someone like a judge who would act as a witness or appear and give evidence as a witness, and a negative finding was made? Does he have any right? And quite clearly, in terms of the common law as it presently stands, he doesn't. That is the question. Then, how do you address that? Now, I would go so far as to submit, and I did say it in the submissions made regarding the directives which were issued in April, May this year, that one of the avenues that would probably be open to the applicant is to refer the matter to the Legal Practice Council, who is the custodian of the interests of the practice, because it would be quite simple simply to place the record or the transcript of the Magistrates Court proceedings before the council and say, I would like a determination on this particular issue of whether this impacts on my right or my ability to practice. So my submission is that the applicant isn't without a remedy as far as that's concerned. And similarly, I think that a judge would be...
Mr. Law, would he, in such a case, have a right to call the magistrate to a professional hearing and cross-examine him or her on the findings that she or he made against him?
Acting Chief Justice, I think the question is not would there be a right to call the magistrate, and maybe this turns on whether that procedure would be dealt with by way of a type of review. And that's why I say I would suggest that the procedure, if that was one of the procedures or one of the avenues that was open to him, was that the record would serve basically as the basis upon which those findings could be, and I'm using the words reviewed, by the Legal Practice Council, whatever body it might put in place. And it wouldn't be necessary to subpoena a magistrate or the person who made the findings to come and say, why did you make the findings? Because it should appear quite clearly from the record or the transcript whether there was a basis for such findings or not. So I'm venturing to suggest that the applicant wouldn't have been remediless in this situation.
Mr. Lowe, sorry, with the presiding justice's leave, can I ask you this? Do you accept that strong criticism against a witness made by a magistrate has the potential to negatively affect the witness's dignity?
Certainly, Justice Rogers, yes, certainly. I do agree with that.
In terms of Section 7.2, the state has the obligation to protect the fundamental rights in the Bill of Rights, which includes the right to dignity. Is that correct?
That is correct, yes.
And Section 38 requires that there should be appropriate remedies where those rights are not respected. Now, what consequences do you say that should have in law? Because let us for the moment suppose that Mr. Lebea's dignity has been violated by the findings by an arm of state in the form of a magistrate. Do you then say, well, by virtue of a limitation exercise under Section 36, this is not, the fact that he is not given a remedy and cannot redress it through the judicial system is simply a reasonable limitation of his rights? Or do you say that there should be some solution?
Justice Rogers, my submission is that it is a reasonable limitation. And I think you asked the question when Mr. Georgiades was arguing, but didn't he have the right to ask to intervene beforehand? If he knew that there was either one or the other finding, either you telling the truth or you're not telling the truth. And on that basis, I would submit that it's a reasonable limitation. To open up the gates for each witness now to be protected to the extent that he would have the right to appeal or interfere with findings, credibility findings of the nature, I submit would lead to great injustices, and therefore, for that reason, it amounts to a reasonable limitation.
I put the question to you in this way in the light of the position adopted in the English Court of Appeal within the last few years,
yes,
where it was held that if a finding is made against a person out of the blue by a judicial officer, there it was a judge, not within the four corners of the case as the parties had presented it to the judge, then that was a violation of the witness's right to privacy under Article 8 of the European Convention for the Protection of Human Rights, that there had to be an effective remedy. And in that case, the effective remedy involved the excision of passages from the judgment. It happened to be very strong criticism directed at a social worker and a police officer, even though everybody, the litigants in the case, had accepted the outcome that the judge had reached. But what is apparent from that judgment is that the solution doesn't lie in giving people rights to appeal primarily. It lies in ensuring that judicial officers who are minded to make unanticipated adverse factual findings give fair warning to the witness. And there's also authority from that same court that if that is done, the witness can't then seek to challenge the finding on appeal as long as a fair process is followed. So would the way to address this not be, I think most judicial officers do hopefully have a sense of fairness and the consequences that their findings can have for people. Would you accept a proposition that as an ordinary rule, if the judge is minded to make some adverse finding against a witness, which that witness could not reasonably have anticipated from the way the case was conducted, that witness might need to be forewarned before judgment is issued and possibly be allowed to make submissions?
Mrs. Rogers, I think that's basically what our submission is, to say, if there was any development of the common law, it might be to the extent that there be some form of a review that you excise, and I think you've used the terminology to say excise. And I, in fact, argued that in the High Court, if my memory serves me correctly, my submission was appeal would not be the correct procedure.
Well, I'm not talking about whether it should be a review or an appeal. I'm rather suggesting that the focus of attention should be to make sure that the trial proceedings, which themselves culminate in an adverse finding, are conducted with due regard to the rights of witnesses. So the position is ordinarily, this is the position in England, and I think it accords with our position, that if a finding is made against a witness on a matter that is squarely in issue in the case, the witness can't complain, although the witness might be entitled to have a lawyer present during the proceedings to protect his interests. But that if a judge is minded to make an adverse finding which is not apparent from the way the case has been presented and hasn't been put to a witness, that finding should not be made without fair warning to the witness, with the right possibly to make submissions.
I think that's basically what the applicant is saying. He's saying he wasn't forewarned, and the decision was one that was not really didn't emanate from the facts, and nothing was put to him in cross-examination. And I would agree that in general, in particular circumstances, there should be some protection. If the finding is such that it does impair the person's dignity and it is an aspect that needs to be protected, and as you've indicated under Section 7 of the Constitution. But then I again say the procedure wouldn't be the present procedure that the applicant is following.
Assuming that sort of process were the general principle, that unanticipated findings, if a judge intends to make a finding which doesn't represent what either side has argued or pursued in the case, assuming that should be the general principle, then as applied to the facts of this case, do you say that, what is your submission about the findings that the magistrate made about Mr. Lebea's conduct? Were they out of the blue or were they not?
Justice Rogers, I think that's been, that is basically why I indicated in the beginning, this is the situation which the magistrate sat with. The magistrate had to make a credibility finding to decide or to justify finding in favor of either one or the other party. And essentially what she did was, on the basis of the evidence before her, she made this finding as a part seemingly of her credibility findings. Although it might seem to be a factual finding, it seems also that it's part of her credibility findings, and therefore it's not out of school, if I can put it that way. It's not out of the blue. And it was part and parcel of what she had to do. She had to come to some finding as far as the credibility is concerned. And this was just one of her findings in that.
So if she was to find that the agreement was concluded, she would have had to find that Mr. Lebea came back after the postponement and told the other side, that's fine, we can tender your costs. And implicit in that is that we are authorized to do so.
That is correct, Justice Rogers. I agree with you. And I think that what the magistrate might have intended doing was to say, and she might the choice of words wasn't good, but that the applicant represented to Mr. Menye's representatives that they had authority. And that was part and parcel of the findings which she had to make, because it was in fact Mr. Menye's case that there had been a situation in terms whereof the representatives of the department were given the opportunity to obtain authority from the HOD, and that they had confirmed afterwards that they had in fact had the authority.
Although the magistrate's decision isn't a model of clarity, it was not clear to me that ultimately it was a case based on misrepresentation. She didn't award damages. She seems to have awarded an amount of money in accordance with the contract that was pleaded.
Justice Rogers,
or do I misread the judgment?
Justice Rogers, that's precisely how I see it. She came to the the conclusion, the finding that there was in fact an agreement that those costs would be paid. And on that basis, she was upholding the agreement. And she found that there was such an agreement. She accepted the evidence of Mr. Menye's witnesses to that extent. That is why I'm also saying that it was in fact a finding that doesn't come out of the blue. The finding relates to whether it was conveyed to Mr. Menye's representatives that the applicant, Mr. Moletsi, had been to the HOD and obtained authority.
And she also seems to have found, I'm not saying that this was a correct approach on the merits, but she also seems to have found that the onus was on the defendant in the case to prove that the internal procedures hadn't been complied with and that the defendant had not proved that.
Justice Rogers, if I have it correctly, that is in fact what she said. She said they are the ones that pleaded an illegality, that there was no authority, a lack of authority, and it was up to them to prove that there was a lack of authority.
Yes, thank you.
So just
Mr. Law, is the statement that the applicant had made a misrepresentation, that the applicant had made a misrepresentation to Mr. Menye's legal representative was neither part of Mr. Menye's pleaded case, nor was it put to him in cross-examination, correct?
Acting Chief Justice, I wasn't part of the proceedings other than being a witness. And I could, whether it was specifically put to him, I think one must accept his evidence.
But you would know the record. You would know the record of, obviously.
If I remember correctly, it doesn't appear from the record that it was put to him.
So we are dealing with a situation where, if that is factually correct, we are dealing with a situation where this was not part of Mr. Menye's pleaded case, and it was not put to the applicant during his cross-examination, but the magistrate just came out with it in her judgment.
Acting Chief Justice, if I
assume it was not even argued.
Acting Chief Justice, I can't tell you exactly what was argued, but the case that was put before the court was, or the causa was in fact that it was conveyed to the that Mr. Menye's representatives, the plaintiff in the magistrate's court, that the applicant, Mr. Moretsi, had obtained the authority, and I think the statements were put to him that what you said afterwards is you didn't have the authority, but that doesn't accord with the evidence. And I think the suggestion was, if you've said that and you're now saying it's not so, then you've misrepresented the facts. And I think it's on that basis that the magistrate came to that finding, although it was not put to him specifically.
So in other words, as you understand it, it would be that as far as Mr. Menye is concerned, the applicant had said he or they had authority and the department would pay, but now subsequently he was saying, no, he didn't say that. So therefore, Mr. Menye and his legal representative were saying the two cannot both be correct. If the position is that you did not have authority, then you misrepresented the position. If you did not misrepresent the position, then there must have been authority.
In fact, Acting Chief Justice, I think that is exactly why the magistrate used the words misrepresented, because it was either you had the authority, and if you didn't have the authority, then you'd misrepresented it to Mr. Menye's representatives that you did have the authority. So
in other words, if you didn't have the authority, you made a misrepresentation then.
Yes.
If you did have authority you are making a misrepresentation now when you say you did not have authority.
That is correct. And I think Acting Chief Justice, just to go a bit further, one of the allegations in the particulars of claim, and it does appear on the record as well, obviously, was that the department can't now go because the applicant was your legal representative, and you can't go behind the representation that was made. You actually stopped now from denying that he had the authority. And I think it's on that basis that the magistrate came to that finding. And my submission is it wasn't out of the blue. It was a finding that was to an extent called.
Okay, all right. Thank you.
So our submission is that given the authority and given the state of the common law, that the applicant was not entitled to intervene. He didn't have a right in the order, and there was no right of his that was at issue that had to be decided to come to the order. And on that basis, he was not entitled to intervene and would obviously not have been entitled to appeal. And I say again, that is quite clearly borne out, especially by the Zulu. And I'm sorry, I don't have the correct pronunciation all the time, but where the similar situation was dealt with, where they said, as a witness, you are in the same position as a witness who made against whom there was a credibility finding made, and you really don't have any right as far as that is concerned. Our submissions are that that it's a reasonable limitation to say that you can't appeal that decision, you can't intervene, having regard to Section 7 of the Constitution, and that the applicant has never had the right to intervene, that the magistrate, when the magistrate refused the application for leave to intervene, the High Court and the SCA were in fact correct. In fact, the SCA said there weren't grounds to grant special leave to appeal, and our submission is that position remains the same. The law is quite clear. The ramifications of the common law being developed in any way, it's difficult to understand how it will be developed. It can lead to such gross injustices, the litigation will never come to an end. We will have such a multiplicity of litigation if every witness is entitled to some form of protection. To meddle in the affairs of private litigation after it has been settled, that there's no room to develop the common law. Acting Chief Justice, unless there are any aspects which any of your justices would like me to address, those are possible.
Yes, thank you. I don't see any indication from any colleague to have a question. I think in that event, we'll go to Mr. Georgiadis for his reply. Thank you, Mr. Elo. Mr. Georgiadis. Well, Mr. Georgiadis, is your position that you accept that if the applicant doesn't have a direct and substantial interest in the sense of having an interest in the order that he seeks to appeal against, then your only hope is on the development of the common law?
That's our position, Acting Chief Justice, that if the common law as it now stands is interpreted against us, that in the alternative we ask that because of the violation of Section 10 and Section 34, access to courts, that the common law be developed.
And of course, you would accept, I would imagine, that Mr. Menya would be entitled to say, when you want to appeal against the order, to say to you, but this order is not against you. This order is in my favor and against the MEC. It doesn't, the order itself doesn't affect any of your rights in any adverse way. So why are you interfering with my order? Don't touch my order. Your interest is against a finding that you made a misrepresentation, appeal against that finding. Leave the order, leave my order alone.
Well, the difficulty with that, Acting Chief Justice, is what I said in the beginning, is that you can't do the one without the other.
But then he will go back to what Justice Nhlanhla, I think, was saying to you earlier, to say you are only doing this because you know you have no case without trying to make a link with the order. Otherwise, in truth, you don't have any, there's no link. You are only doing it because you know if you don't make a link, you would have no case.
If I don't make a link, the essential link, then I'm out in terms of the common law. I have to make the link that there's an essential part of the order was the finding.
Yes. Okay, all right. Is there anything else you wish to say in reply?
Acting Chief Justice, I promised to come back to you on the issue about whether it was put to him in cross-examination. I found that reference. It's at page 366.
What page?
Volume 4, page 366.
Yes.
He says the case of misrepresentation allegedly perpetrated by, this is the affidavit of Mr. Lebea in the founding affidavit. He says the case of misrepresentation allegedly perpetrated by me was not pleaded in the first respondent's particulars of claim, and the version that I made a misrepresentation was never put to me where I testified. Again, Mr. Menya only boldly denied this allegation in answer. He then gives the reference in the finding affidavit of the intervention application, which is paragraph 8.
Okay, okay.
I haven't addressed justices on the condonation issue. I don't know if Chief Justice wants me to cover that. It's basically
how long was the period again? 10 days or something?
I stand corrected, but it was he only found out that the DS lapsed on the 10th of July, and he only came to his attention on the 20th of July when his offices reopened because of the COVID breakout that occurred in his offices. I think
yes, but do you have anything further to say other than what you have said already in the papers? No, Acting Chief Justice.
Yes,
and I don't think Mr. Menya's counsel makes an issue of it.
No.
If I'm not, yes.
Yes.
Okay, all right. Mr. Law, I'm right about that. Is that correct?
That is correct, Acting Chief Justice.
Yes. Okay, all right. That's your address in reply, Mr.
Yes, Acting Chief Justice. I thank you, Acting. Those are awesome.
Thank you. Thank you very much to both counsel for your submissions. We will adjourn to consider the matter, and obviously in due course you will be notified once judgment is ready to be handed down. Judgment is reserved and the court adjourns.
Thank you, Acting Chief Justice.
Today's proceedings have concluded. The host will now terminate the meeting.